Hello and welcome to the Minimum Competence episode for Monday, March 11th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have a judge blocking an NLRB rule affecting contract workers, a 96-year-old judge's suspension debate, J&J's legal battle over benzene in acne products, and a pivotal Tesla autopilot trial. Let's remember the only way out is through today's legal news, that is. On this day in legal history in 1985, Mikhail Gorbachev became the new leader of the Union of Soviet Socialist Republics, or USSR, following the death of Konstantin Chernenko. At just 54 years old, Gorbachev was the youngest member of the Politburo and brought a new vision for reform to the stagnant Soviet system. Domestically, he introduced policies of glasnost, which means openness, and perestroika, which means restructuring, to liberalize the economy and allow greater freedom of expression. These sweeping changes appended decades of repressive Soviet policies and paved the way for democratization. On the international front, Gorbachev pursued arms reduction negotiations with US President Reagan, easing Cold War tensions. In 1987, they signed the historic INF Treaty, eliminating an entire class of nuclear missiles from Europe. Gorbachev's reforms proved too fast and destabilizing for the Soviet system. In 1991, hardline communists attempted a coup against him, which failed, hastening the dissolution of the USSR into independent republics by year's end. For helping end the Cold War without bloodshed, Gorbachev was awarded the 1990 Nobel Peace Prize. His legacy remains complex, but he is widely credited with allowing self-determination for Eastern Europe and averting catastrophic conflict. A federal judge in Texas has struck down a rule issued by the National Labor Relations Board, or NLRB, that would have expanded the definition of joint employer to include many companies that contract or franchise workers. The rule would have treated those companies as employers of the contract or franchise workers, requiring them to bargain with unions representing those workers. The judge agreed with business groups like the U.S. Chamber of Commerce that the rule was too broad and violated federal labor law. The NLRB chair said that they are considering next steps, likely an appeal to the Fifth Circuit Court of Appeals. The rule was intended to ensure companies can be held liable for labor violations when they control key working conditions of contracted franchise workers. However, businesses argued it would disrupt franchising and contracting agreements. The joint employer issue has been contentious, with shifting standards between the Obama, Trump, and Biden administrations. A committee of judges on the U.S. Court of Appeals for the Federal Circuit argued that a lower court should dismiss the remaining parts of a lawsuit filed by 96-year-old colleague Pauline Newman over her suspension. The judges claimed the law governing Judge Newman's suspension for an investigation into her fitness to serve is constitutional, despite her challenges. Newman's attorney plans to respond to the arguments made. Last month, a federal judge dismissed most of Newman's other allegations against the Judicial Council that suspended her. The council suspended Newman in September of 2022 for at least a year amid concerns over her mental competency, which she has defended. The judges argue even if some suspension orders could violate the Fourth Amendment in certain situations, that would not make the governing law unconstitutional overall. By way of very brief background, Judge Newman contends that certain elements of what was demanded of her violates the Fourth Amendment as they are unconstitutionally vague under the Due Process Clause. Specifically, in counts 8 and 9 of the complaint, linked in the show notes, Judge Newman argues that the Act's authorization of demands for medical records or examinations without a warrant based on probable cause or constitutional reasonableness violates the Fourth Amendment. However, these claims are likely legally untenable for multiple reasons, including the failure to meet the standards of a facial challenge. Customers have filed a proposed class action lawsuit against Johnson & Johnson's subsidiary in Los Angeles federal court. The suit alleges J&J failed to warn customers that its acne products like Clean and Clear and Neutrogena contain benzene, a cancer-causing chemical. The customers claim they would not have purchased the products if they knew about benzene and associated cancer risks. This comes days after an independent lab alerted the FDA about high levels of benzene in popular acne product brands. The EPA has stated breathing low levels of benzene over a lifetime can increase cancer risk. The suit accuses J&J of ignoring the FDA's 2022 warning to test products for benzene contamination. It seeks to represent a national class and subclasses in several states against J&J's alleged failure to warn. A new trial involving a fatal 2018 crash while Tesla's autopilot was engaged will test the company's defense that drivers must remain attentive and ready to take over at any moment. Lawyers for the plaintiff are citing internal emails and testimony suggesting Tesla new drivers could become distracted or complacent when using autopilot. They argue Tesla should have studied how quickly drivers can regain control if autopilot fails. Testimony indicates Tesla did not research this issue until after the 2018 crash and only added driver monitoring cameras in 2021. The case could pose a significant challenge to Tesla's stance that autopilot is safe if drivers follow instructions. It highlights questions about Tesla's knowledge of likely driver behavior and obligation to design safeguards against foreseeable misuse. The outcome may influence other lawsuits Tesla faces over accidents involving its driver assistance systems. And with that, I thank you so much for listening to Minimum Competence and bearing with me while my voice is a little bit wonky. This is your daily news podcast for lawyers, and if you're looking for more than Minimum Competence, you can find links to further reading on all the topics touched on today in the show notes. Reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, half the world is composed of people who have something to say and can't, the other half who have nothing to say and keep on saying it.